common knowledge that the office of the DPP is not privy to what happens in the General Court Martial. And the office of the Director of Public Prosecutions under Constitution is in charge of civil justice system. In that, my Lord, as office of the DPP, were not aware that the accused person stroke applicant was arrested from Nairobi. Because we are not privy to military justice. My Lord, after charging the applicant stroke the accused persons on the 21st of February 2025, we committed them 29th of May 2025. My Lord, it's not true that applicant was committed without legal representation. His counsel appeared on that date and on record of the Chief Magistrate of Nakawa. They just decided to walk away in protest. An act that would not in any way, my Lord, affect the procedure of committal of the accused person to the High Court. Because the substantive justice before Chief Magistrates courts in capital matters such as this one is either commit or release the accused person not to proceed. And by that time, my Lord, the investigations were over. And now the office of the Director of Public Prosecutions was to simply exercise its mandate under Section 168 of the Magistrates Court Act. After committal, my Lord, prosecution was ready to have the accused persons or applicants tried. However, as rightly put by the applicant, the one senior citizen, Dr. retired kizza Besigye, they bombarded this honorable court with several applications, some of which made the hearing of this case at that time practically impossible. So we've actually wasted about 6 months in applications, my Lord. This is not to say that the applicants or the accused person do not have the right to make those applications. We appreciate that it was all within his right. Our argument is that those several applications affected the fair trial. I mean the quickest or a quick trial of this matter. My Lord, we started disclosing this matter right from January. And my Lord, what was remaining were basically about 5 statements. For witnesses whom we thought were at risk of intimidation, harassment, and compromise, among others. It is on that basis that we filed an application, sorry, my Lord, an application for protection. My Lord, that the deponent in that application, the land Chief State Attorney Joseph Chomuhendo, was cross-examined for 2 days if not 3, almost. Because prostitution, my lord, was interested in a quick and speedy trial, not disputing fair trial, we decided to withdraw that application. Much as protection of witnesses is part of the fair trial. So we compromised the protection of our witnesses for the sake of having this matter heard. After withdrawing our application, we fully disclosed the remaining 5 witnesses. The statements for those remaining 5 witnesses. Defense. And we intimated to them, or to this court, my lord, that we are ready to have the matter start. Defense brought another issue that we had to agree to some issues or facts which prosecution never had. And they were raising, but they were not specific with those issues. And because of that, my lord, this court made an order that prosecution brings or presents its witnesses. We brought our witnesses, my lord. We brought 2 of them that time. Although for their statutory reasons, they were not in this honorable court. But some were very close to reach of this court. The applicants spoke their accused persons say filed an application for human rights enforcement. Against General Mhoz Kenevugaba and 3 others. My lord, on the 11th of June, this court issued gave out schedules. Gave directives on schedules that application. And my lord, the main case was adjourned to the same date of the hearing of that application on the 30th of June, 2026. My lord, on the 30th of June, 2026, court fixed the bail applications for A1 and A2. That is application number 213 of 2026, and also that's application number 0698 of 2025 for A3. My lord, the reason why these applications were fixed is because counsel for the applicant stroke accused persons had requested court previously to have the same disposed of. So the demand was to dispose of the said bail applications, the human rights enforcement application, and then they also asked for facilities to be availed both at court and in the prison. That is the reason why, my lord, the two bail applications were fixed. And also, in order to address the issue of facilities, this court, the accused persons brought to court prisons. I will come to that later, my lord. Let me first finish up the issue of their application. My lord, on the 30th, court issued directives that the respondent files their reply by 1st of July 2026, and that the applicants make their rejoinder on the 2nd day of July 2026, if any, and then it was fixed today for hearing at 2 p.m. My lord, just to remind this court, the accused persons, is that on the 30th day of June 2026, counsel for the applicant stroke accused persons led by Council Tugumi. Informed the court that they were ready to receive the directive or directives on all schedules. That's why this application was fixed today, or the two applications were fixed today. My Lord, this application, that is 213, okay, was not solely filed by Senior Counsel Martha Karua, Counsel Department. I think it was filed by so many. It was a joint application. If I remember very well. Okay, the farm for council, Senior Counsel was part, but there were other farms which worked very hard to file this application. Council Tugume on the 30th of June 2026. Let me just make it clear that neither counsel for the applicant nor the applicants expressly informed this court that this matter wouldn't take off today. We appreciate that the issue of representation came up, but they were not the point that this application would not take off. And as a result, my Lord, the respondent complied with the directives. We filed our response by 1st of July 2026. My Lord, as it has been a culture between counsel for the applicants and as counsel for the respondent, we have been having a cordial relationship in terms of service. Much as ECMIS, when you file an ECMIS, the other party is deemed to have been served. We have been having that cordial relationship that we normally serve the hard copy of our pleadings. So it is because of that relationship that we thought we could serve counsel in this matter. Our surprise, they say they cannot receive our service because they had no instructions. was surprised, my lord, because we hadn't seen anything on record for withdrawal of instructions. And that was the basis of the respondent serving the applicant's counsel. So, my lord, as we came today, the respondent is ready to have this application prosecuted. And my lord, matters such as this one is normally the applicant who should be interested in having the application prosecuted. My lord, before I go to the tail end of this application, I just wish to say a few things. The applicant raised the issue of counsel being arrested. My lord, we are aware that he was charged with misprision. However, we are not aware that he was arrested by General Muhoozi. We are not aware, my lord. And we are also, my lord, not aware that Senior Counsel Martha Karua, whom we respect here, was deported and declared persona non grata by General Muhoozi. My lord, we have always respected the representation of the applicant stock accused persons, and we shall respect that because it forms part of his constitutional rights. My lord, the applicant submitted that he sympathized with his legal team, and as such relieved them of their duties. I hope I got him very well from that. And he said that until the recent application concerning his representation is addressed. Nothing actually happened, and is willing to stay in prison. My Lord, it is a submission as respondents that since the applicant is anxious to leave prison, then he should have allowed to have this application prosecuted. My Lord, we are inclined to submit that this court has powers under Section 37 of the Education Act to give any remedies to a party before it, and my Lord, our remit is under Section 72(2)(a) of the Education Act. I mean 17(2). Section 17(2), Section 17(2)(a) of the Judicature Act, Cap 16, to have, my Lord, this application dismissed. This application, my Lord, can always come up because as respondents, we are not aware of the application in respect to his legal representation. So it will be hypothetical and speculative on our part, my Lord, to start scrutinizing the merits of that application at this level. So this dismissal, my Lord, is intended to curtail any delay in trials, which emanate from abuse of the legal process. This is not to say that the applicants, that as respondents, we don't believe in the applicant's right to apply for bail. We believe in that. And that's why, my Lord, we work tooth and nail to ensure that we file our response by 1st of July 2026. Under pressure But the reason was to ensure that we prepare Article 28 of the speedy trial, my lord. 28 of the Constitution, my lord, in respect to speedy trial. So, my lord, we so submit. My lord, just something which I'd forgotten about. We received a copy as respondents of a letter from prisoners. From, yes, we got a letter from the registrar attaching a response from Uganda prisoners dated 29th of June 2026. My lord, this letter is to the effect that the prisons authority have granted, have granted, and, and they are going to provide facilities to the applicants, stroke accused persons, which they initially prayed for. Although, my lord, we are not privy to the letter which he talked about, which Colonel retired Dr. Kizza recently talked about that he filed, whereas the respondents are not privy to it, so we do not know the details of the said letter. Nonetheless, we reiterate our earlier submissions.
Yes, just a few responses. Understanding of what cognitive process in respect of believe is not in line with the law. The trial, the seriousness that has been so much talked about. Yes, I could, as right, be represented on stage, especially you know, is a serious stage. was our right. Regarding disclosures, again, the point was made here in court. The reason talk about full disclosure that you can only know the whole case once you have all the information, not parts of the information. We are only able to know whether we have all the information on June the 1st. So the disclosure began in January, continued piecemeal all the way. More critically, the main thrust, the essential element, the disclosures, is in electronic documents. Videos and audios. Which, regardless of when they were passed on to our council, up to this day, as we stand in court, we have never received even them or had them. Those order for facilities to do so was given in this court on that first day of June. The registrar, deputy registrar for the case, was supposed to communicate those instructions to the prison authorities. To the best of my knowledge, instruction about facilities being accessed in the prisons to view these things has never been communicated by the deputy registrar of the prison. less because the OC is informed. But the deputy registrar wrote, the letter was read to us as for provision of time in weekends, public holidays, accessing. When our lawyers heard what was communicated to them, they came back to the registrar, informed about the problem that still existed. Since there is a letter in court with the prosecution, maybe they can help courts to read to us that facilities have been allowed in the prisons. To be news that I used to me.
There are two letters.
One from kizza.
Prison. My lord, this letter is dated the 29th of June. Dated 29th of June, 2026. 29th of June, 2026. My lord, it is addressed to the Deputy Registrar of Criminal Division, Kampala. Go ahead, my lord. And it is in response to requests presented by lawyers in the criminal section case number 335 of 2025, Uganda versus Kanurita, Dr. Kizza and others. 1. Reference is made to Kampala High Court Criminal Division Deputy Registrar 18th of June 2026. Reference guidance on requests made by lawyers in criminal section number 335 of 2025, Uganda versus Colonel Retired Dr. Kizza Besigye and others. 2. Below is the response to the respective requests. The lawyers of the accused persons be provided with unrestricted access to the prison facility from 8 a.m. to 6 p.m. to ensure preparatory meeting time as required for purposes of taking a full account of the events and identifying the potential witnesses for accused persons and attending the facility with such people from time to time. Response: access granted from 8 a.m. to 5 p.m. B. Lawyers and the accused person will be provided with an interview room free of any officers of the state and which is large enough to accommodate 15 to 20 lawyers and any assistants to ensure that the advocate, client privilege, and necessary confidentiality is accorded. Response. The spacious room large enough to accommodate 15 to 20 lawyers and any assistance is available and will be provided. Second response. The client advocate privilege of confidentiality will be accorded with the prison officer being in sight but not in the meeting of the ongoing interaction as provided for under section 63.3 of the Prisons Act, Cap 325, Regulation 54.3 of the Prisons Regulations 2012, and Chapter 38, Paragraph 8, Subparagraph 5C of the Prisons Standing Orders, Part 2, 2017. C. Lawyers of the accused persons be permitted to bring into and take out of the facility on each day of consultation. A. Projector and whiteboard stroke background. Response. This will be provided. 2. Laptops, mobile phones, ear stroke, headphones, and mini sound speakers. Response. Laptop, ear stroke, headphones, and mini sound speakers will be provided. B. The mobile phones are not granted entry into the prison, but can be kept at the outside visitor handling office where the lawyers can access them with ease. Mobile phones are key prohibited items in prison as per Chapter 45, Paragraph 2H of the Prison Standing Orders 2017. 3. Internet connection, which is secure to facilitate on-spot research. Response. This is not granted in the lawyer's interaction room, but we shall avail an alternative nearby room equipped with internet accessible to only lawyers for research on need basis. D. An IT expert of the accused person's choice to assist in defense preparations be allowed to prisons with lawyers of the accused persons. Response. This is hereby granted, but upon full identification. E. A forensic examiner of the accused person's choice to assist in defense preparations be allowed access with the lawyers of the accused persons. Response. This is hereby granted, but upon full identification. Lawyers of the accused persons be allowed access to the facility with all case files, flash drives, notebooks, pens, statute books in hard and soft copy as may be deemed necessary for effective consultations. Response. Grant of access is hereby accorded to all case files, notebooks, statute books, big crypto ballpoint, pens, and flash drives containing only electronic evidence and soft copies of statutory books. G. Permission to access the facility with the necessary meals and refreshments for those attending the consultation sessions. Response. The refreshment that is packaged water is hereby granted for the lawyers. The accused person's refreshment will be got from their internal stock. While for food, the lawyers are at will to have scheduled meal breaks, as the accused persons also go back to their residence for their internal. H. Lawyers representing the accused persons will be granted access with the required confidentiality to the accused person at court before commencement of every court session. Response. The interaction with the accused before court commencement is granted, but subject to security assessment and controls. Most obliged. On TO for Commissioner General of Prisons.
I wrote as you had that letter is 4 days ago. Actually, your lawyers haven't seen it because it came during the crisis we are talking about. And the rest is some progress. Okay. If and as we are able to assemble a legal team, hopefully that letter will be made available to us. Is it copied to any of our?
Yes, it was copied, my lord, to defense counsel. And yes, and state attorneys.
The surface I could hear precious areas. I guess those will be dealt with once or if we resolve the question of the but PPP continuously refers to speed the trial, keep trial. Says they withdraw the Tom handle. Application for witness protection. Facilitate that if tried. And expose their witness to risk which they were trying to protect. So, Mr. Judge, can you imagine they are seeking to protect army officers, civilian officers, and they are now worried about their security. Where does that leave our lawyers who are directly threatened by the senior-most military officer? Military officers themselves needed protection. And imagine what we are faced with. Those who need protection, general was. Preliminary hearing, the facts is only one element of the preliminary hearing. All these others are part of that. And agreed facts, if they are none, it's just recorded that they are none. But the legal requirement that if they are agreed facts, agreed documents, and their memorandum is worked out and signed by all parties. But to conclude preliminary hearing, when these other matters had not been dealt, including this application, including the access, the disclosures, because preliminary hearing, and the trial was supposed to begin on 11 June. This letter, which is now giving access, is on 29 June. And there rests our concern. We are expected to come here on 11 and face a witness before we access the disclosures. Surprised to know that comments in the matters of our application for human rights. There is not a party. Maybe the reality is that he is actually a party. When the Attorney General introduced prostitution, when he was introducing him, we thought it was a slip of the tongue. Now, prostitution is telling us what happened on the 30th in respect. These proceedings. Regarding the bail, and if we were really interested, as we are, in getting freedom, liberty, under threat, I haven't seen him since. I don't know whether he's in hiding. If counsel, Brunei, the few lawyers who were here created the impression that they were a team instructed to continue prosecuting these matters. Was would be a wrong impression. We met the lawyers before we came here. The court cells down here. clear understanding that they were coming to raise the alarm about their situation. Indicate how the team has been decapitated, rendered unfunctional. You are decapitated. Richard William would forgive you all that. If you are decapitated, you can refer to the body as still able to continue doing something when it has lost its head. Simply can't happen. Because the body functions as one. Some parts are not as critical as others. They lose a finger, they even lose a hand. When you are decapitated, the head is removed. How to build respiration. So, if pressure was created, that by their presence, they talked very clear and loud and important in my presence here, about their dilemma. I think one said that he was even not out sure whether he could report. So that our team is simply whether it's one or two or three, they function as a body, was rendered dysfunctional. Now is how to deal with. This comes with they told you the truth, but there was no instruction. A response they don't have mechanism for sales. Don't even have they have not communicated. Yes, they have to communicate. I'm inclined to agree that does not. General Muhoozi Kainerugaba is behind the arrest. This was the responsible for the arrest of and for the deportation of inclined to believe. That is why we find that application 248 so that evidence is adduced, show that he is responsible. The respondent is responsible for the terror. Which is due. regarding the recommendations, dismiss this very application. I think we've been very clear that we are very keen on the bay. Indeed, these applications have been hard in accordance with the bail disposal regulations that are in place today. This crisis would never have arisen. Bail disposal regulations which are in the Constitution, bail guidelines for courts of judicature, practice, directions of implementation. They provide that bail applications should be disposed of within 30 days. Our bail application hard and disposed those 30 days since we will not be here. As I pointed out in the case of my co-accused, Kenona, the application is of last year. So we are simply incapacitated act because of the reasons I have presented to court. We have challenges of legal representation and therefore of communication. We didn't receive your reply. We can't rejoin the reply. We are simply stranded. Also indicated that our witnesses, at least one of them, under threat. They show one of their sureties. So I don't leave it to the court. Dispose of it. With all those concerns.
submitted. Now, Samina has testified. I will deliver this ruling next week in case, and I'll deliver it to Nicholas, and I am ordering that the hard copy be delivered to you in Luzira through Luzira by 3. I have the second application.
Business application number 698 are also
For the prosecution, Thomas Jatiko, Assistant APP, still appear together. My land friend, Richard Ibumbuka, Chief State Attorney, and George Bigira, Senior State Attorney. And what became ready to proceed bail question here.
Before I express the reason why Maharaj is not present, I want to reiterate some of and that to be specific in regards to our success. After that, there is a letter of 8th of June, trying to address that. So that all of us were free to descend by them. But on the way, I'd like to bring to the attention that as I speak, I'm actually making almost 3 years in detention. And really it is in my interest that this bail has to be disposed of. Bail is of 2025. And as I may recall, it was first fixed for hearing in March. It was supposed to take place on 27th of January 2026. But before that hearing would take place on 25th of January, a production warrant was produced. Even rescheduling that the hearing will happen on 26th of February 2023. On 25th of February, a letter from the deputy registrar again went to the prison, which I received actually on and not therefore not annually. Every time that court schedule a hearing, I have to transport the sureties all the way from Gulu to come and attend. And for those two occasions, the cancellation comes when they've already traveled. Yet this money I have to source from relatives, friends. Also putting into consideration that communication itself, we went back to prison, I access communication Wednesday, that out to my relatives and friends who facilitate my lawyers and the sheriff. And he promised me to write to you, inform you. However, as I was entering here, when we were got here, I received information. One, that a letter was actually written to you, informing you of the same, and requesting you to adjourn this hearing to the nearest date possible. The second information I received that the resources that I needed to facilitate my sureties and to facilitate the lawyers to be present in court, finally in court. It's my humble prayer, putting into consideration the time this bill has spent before the court, into consideration the time I've spent in detention, and putting on consideration very, very challenges that both me, my siblings, my children and family are faced with. Relying on other people, it will only be just for this honorable court fixed the hearing. Here, so that it can be disposed of and get to know the fate of
Professionals in record you are talking about. You get the reply.
Why don't we have no objection to prayer? Applicant Captain Dinesh Bola for the adjournment to another date to enable him and his lawyer prosecute his application.
Give my ruling on the adjournment of the case. Please, off record now. I've now finished this matter. Doctor, I have listened to you. That you started by saying that when you are starting to talk and don't listen to me, I will now go to the press. But if you don't know the language of court, then we shall have to discuss. The moment like now I have adjourned. Honestly, the language of court is what has been adjourned. When we start reporting that the judge has run out of court, that one we shall discuss. The matter is adjourned. Now, like now what really I'm saying, I'm communicating, is not part of the proceeding. Doctor, honestly, I have listened to you from day one, not only today. Even, I think in those incidents where you saw saying that the judge ran out of court, of which, honestly, we had agreed with judiciary. You can take all the photos as you want, but not here. Not when I'm entering, not when I'm going out. You want us, who are here to inform the public, but actually, I have no problem with that. So, Carlo, I have tried my best to listen to you, and it was important that I listen, and when you conclude, I have said matters of judged and given a date. When you continue talking, and you go away, it means there is no way I can write right now. So, bear with me, but let us understand the process. What cannot happen. You have been here since 11. I mean, it was now coming to 6. So, it's a right that I must listen. There is no compromise from that. I have already said that equally what you are saying is that right of fair trial, you can't compromise. So what we need is Africans, finally, in public. Honestly, let us agree. I have, if I can tell you the struggle I have gone through, when they want to pick you for content of court, you can't do it. I have struggled, I have refused. Starting with Miriam Mutari, is she here? Not here today. People insisted that I order for content for court here. I refused. They took her to CPS. They came, I said no. Reason? Said I was aware that she's a daughter, she's representing. As a human being, I said probably emotion cannot be talked about. What they are talking about is Babu's grant. One of them can't say that the lady who was here and did what she did. I didn't. Judge, counsel, doctor. You said that some people were arrested in the commercial. I was not there. The lawyers. That one you can't talk about it. English, you cannot think about it. You cannot think that the judge at least saved this Miriam Mutari for content. Here you go at CPS and refuse. I have done other extra miles. With BBC, refusing people enter. I made here something, but one kindly around the relatives, around the people enter court. But that one, whether the press, whether the English singing, cannot talk about it. Now, so let us just respect. I know the emotion, but let us respect. I'm not the one who took these processes. Honestly, sometimes I say, if I don't interact with them, that was the persons I have told to the prisons, allow people to be here. Allow people to interact. I have reached the point that even now, before you come, I told the lawyers to interact with you. Not I'm aware when you say they are child, they said it's okay. Interact with them before you come. With relatives here in court. But cannot be found. So, currently the public now, what do you lose really to wait after here and receive from outside? But if this court order is also putting on pressure, I am provoking the mystery, let it go. Don't charge people. Now is also blaming me for promoting the this and look at the court. Now, the press now capitalize on my communication. Now, the news is there for what has happened as a process. But now, in-house, yeah, these are in-house things. And I have requested, I think I have made with the team in-house things. Some problems have been solved. So, the challenges can be solved, but not as a battlefield. Not as a battlefield, but we can always discuss. I have several times forced the constitution to attend the meeting. Sometimes they no, we can't attend that meeting if they have requested facilities in the city. We are not part. I said, come, let us listen. Okay. Now, as I conclude, as I understand, like that later, I think it is weakness, but since you have a challenge of accessing weakness, I'm going to direct the registrar prison to get a copy. So now they cannot access, it is the weakness. But because it is a weaker than weakness, get that later, detailing the facilities. Let them take.
No, this one is
subscribe.